Welcome and thank you for joining session 5 of Seyfarth's webinar series, Commercial Litigation, Insight and Predictions for the Transportation and Logistics Industries in 2023. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window, and we will do our best to get everyone's questions. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. The webinar recording will be distributed to attendees in the days following the webinar. And at this time, I would like to turn the program over to our presenters to begin.
Thank you. I'll start. My name is Dawn Mertnight. I am a litigation partner in Seyfarth's Boston office, and my practice is largely devoted to trade secrets and restrictive covenants issues, and I am a co-editor of Seyfarth's Trading Secrets blog, which you can access at tradesecretslaw.com.
Hi.
Go ahead, Allison.
Hi, my name is Allison Eggers. I am also a partner in the Boston office in the litigation department, and my practice focuses on antitrust and franchise and distribution issues.
And good afternoon. My name is Brandon Bigelow. I'm a partner at Seyfarth Shaw. I'm the head of the antitrust practice group at the firm. And my practice focuses primarily on counseling manufacturers in antitrust compliance and related litigation, as well as other trade regulation litigation.
So I have the good privilege today of being the moderator and bringing together two interesting practice areas, trade secrets and antitrust, which I think is particularly interesting right now from a regulatory perspective. The FTC has been a significant presence in both of these areas lately. So I wanted to start there, and I'm going to start it off with Dawn. So Dawn, just last week, the comment period closed on the FTC's proposed rule regarding non-compete clauses. Could you give us a little bit of background on the proposed rule and what happens now that the comment period has closed?
Sure. So this has obviously been a very big deal in my world. You may know, or you may have heard that in January of this year, the FTC issued a proposed rule which would ban virtually all non-competes. Now, when I say virtually all non-competes, I mean it. There were two exceptions to the rule, to the proposed rule, I should say. First, it doesn't affect agreements between a franchisor and a franchisee. And second, it would permit non-competes in the sale of a business, but only where the seller of a business has at least a 25% interest in the business that has been sold. This was very concerning for a number of reasons. Again, the exceptions to the proposed rule were very limited. There's no exception for executives. But one of the things that I found very concerning was that this proposed rule would have a retroactive effect. So an agreement that was entered into yesterday, which is currently binding, enforceable, legal, could end up being unenforceable. And in fact, if the FTC has its way and the proposed rule goes into effect as currently drafted, employers or other businesses would be required to inform the parties bound by these agreements that they are no longer enforceable, that they have effectively been rescinded. Again, in the context of this webinar, it's concerning because we have a lot of clients in the transportation and logistics industry that have made strategic investments over the last several years, made acquisitions, and usually part of those transactions is a non-compete. So obviously, if company A is purchasing company B for millions or even billions of dollars, frequently there is a non-compete that's part of that deal, because once company A pays the owners of company B, let's say $1 billion, they don't want the owners of company B to just turn around and tomorrow start competing. Now, typically that's fine, and as long as the non-compete is not overbroad, the FTC or the various regulators have been fine with that. But the FTC is coming in now and saying, well, if company A spent $1 billion acquiring company B, but one of the owners of company B has 24.5% interest in that company that was sold, they can turn around tomorrow and they can start competing. Anyone who has some familiarity with this area of the law probably knows that California is particularly hostile to non-competes. A way to illustrate how extreme this proposed rule is to tell you that the FTC's proposed rule goes even farther than California law. California law also has a carve out for non-competes in connection with the sale of a business, but it doesn't have this threshold, this 25% threshold, at least not yet. So that's a real concern for our clients, not only as they look forward for potential acquisitions, but looking back at the money they have spent to purchase certain companies or to merge with certain companies, now knowing that those non-competes may not be worth the paper they're printed on. So you mentioned, Allison, the comment period. The FTC, like I said, gave notice of this proposed rule in January. The initial comment period was through mid-March because there was such interest in this area, you know, some pro, some con. There was a request that the FTC extend the comment period, which they allowed. The comment period ended last week, April 19th, and they received over 25,000 comments.
So I know you don't have a crystal ball, obviously, but given the number of comments that came in, and I know the FTC, as part of the rulemaking process, you know, almost always says, we're going to review everything very carefully. We're going to, you know, then proceed. Do you have any idea what the timeline looks like? If there's any chance that maybe the rule doesn't go into effect, depending on what the comments say, like kind of what's next?
Yeah, so obviously it is hard to tell what they are going to do and what the timeline will be. It's possible that the FTC could look at the concerns that many in the business community have shared and say, you know what, we don't think we want to do this anymore. I would be very surprised. My money is that the FTC is going to move to implement a final rule. You know, there's a chance that certain things will be changed. You know, I wouldn't be shocked to see the retroactivity aspect change, but we just don't know at this point. Now, what will happen even after the FTC implements a final rule, typically there will be a period of, we would expect 180 days before it will go into effect. And what will almost certainly happen is this will get tied up in litigation almost immediately. And frankly, it is most likely going to the Supreme Court. This Supreme Court, if I had to bet, would strike down any proposed rule or any final rule that goes into effect, because we saw in the last year, the Supreme Court has really limited the ability of agencies to implement rules like this. So what I have been telling my clients is, you know, there's nothing to worry about just yet. You know, there might be a final rule. There's going to be some time that it gets litigated. And ultimately, I don't think that this will be held up, but it is something that you want to keep your eye on.
Yeah. So picking up on the Supreme Court and the trends that we're seeing there, you know, I know Brandon and I pay close attention to what's happening in all things FTC because of our practice area being an antitrust. And, you know, 2 weeks ago, the Supreme Court issued a unanimous decision that held that companies and individuals facing agency investigations or complaints, you can go right to federal court with certain constitutional challenges, including the use of administrative and, you know, in-house judges to handle those cases. So I wonder, Brandon, can you talk a little bit about, you know, what this means and what it portends for the future?
Sure. So in the Axon versus FTC matter, just a decision just issued within the last couple of weeks, the Supreme Court didn't actually hold anything with respect to the agency's current power to use in-house judges, administrative law judges appointed by the commission to resolve certain kinds of disputes. All the Supreme Court held was that a litigant could challenge the authority of the Federal Trade Commission to force people to go into that administrative process under the Constitution. Specifically, in the Axon case, Axon back in 2018 had acquired another company called VView for $13 million. These are two competitors in the police camera market, if you will. And so this was a $13 million acquisition, well below the Hart-Scott-Rodino threshold. So not something that the parties advised the pre-merger notification office about prior to consummating the transaction. 2 years later, the FTC notified Axon that it intended to force Axon to unscramble the eggs, if you will. They said that the acquisition by Axon of VView in the FTC's view was anti-competitive, and the FTC informed Axon that it would be going in front of an administrative law judge appointed by the FTC commissioners to determine whether, in fact, the acquisition was going to have an anti-competitive effect in a relevant market. Axon did something a little unusual. Instead of just going in front of the administrative law judge, Axon went to federal court instead and said, hey, judge, there's no way that this administrative law judge can fairly handle this dispute. This administrative law judge is not adequately accountable to the President of the United States, and this is a violation of separation of powers. And in addition, here is an administrative law judge whose paycheck is issued by the same folks who are suing me. So here, the FTC is essentially not only investigating me, not only prosecuting me, is also going to adjudicate the claim. And oh, by the way, the FTC commissioners are going to take the first crack at any appeal. Seems unfair to me, says Axon. Unfortunately, the federal district court judge said, well, you'll get a chance to make that argument, but first you got to make that argument to the administrative law judge. And the Ninth Circuit affirmed that decision. Now, actually, there was a parallel case down in Texas, similar situation, but involving the Securities Exchange Commission. So those two cases went to the Supreme Court, and the U.S. Supreme Court said, no, that's a fair federal question for a federal district court judge to decide. So, but the court didn't actually decide whether, in fact, the use of an in-house judge at either the FTC or the SEC would, in fact, violate separation of powers in any way, whether in fact, it was unconstitutional. The Supreme Court remanded. So now the district courts in Texas and Arizona will have to make some fact-finding and then make a determination. It's almost certainly headed back to the Supreme Court, and so time will tell. In the meantime, Axon continues to function as the merged entity with VView. In terms of what's next, well, like I said, first, we're going to see more activity in this space probably over the next 2 to 3 years. It's important to note this is not the first challenge recently to the FTC's authority. This was a unanimous decision. This is not a partisan issue. This is a 9-0 determination that in fact the courts did have the power to at least decide whether the FTC can use in-house judges. It'll be interesting to see whether it's a 9-0 determination in the next go-round when they actually the Supremes actually resolve that dispute. But there is some unanimous skepticism about the authority of the FTC. Just a couple of years ago, in fact, in the AMG case, AMG versus FTC matter, the Supreme Court, by a 9-0 decision, held that the FTC does not have the authority to, seek equitable remedies for violations of Section 5 of the FTC Act, which immediately took big money recoveries by the FTC off the table. Now, the FTC has, since that time, been working with state attorneys general trying to find workarounds, essentially partnering with states under the state little FTC acts to try to get monetary, remedies. But, again, AMG was a 9-0 decision. And so there's real skepticism, I think, at the Supreme Court about whether the FTC really has all the power the FTC thinks it has.
So I want to stay at the federal level for a couple more minutes, but maybe kick over to the DOJ, which is one of the other regulators that plays an outsized role in our lives in certain practice areas. The DOJ has been bringing over the last couple of years quite a number of criminal cases, particularly in the labor market area, looking at the antitrust implications of various labor practices. And, I'm always surprised when I look back at the cases or get news alerts as to how those are going, because it seems like the DOJ is not having a great time there as well. So I was wondering, Brandon, if you could tell us a little bit about some of the criminal cases that the DOJ has been bringing, what's behind them, what's driving it, and if there's anything in particular that employers should focus on from a risk mitigation or a practice perspective.
Yeah, nobody should be surprised that the DOJ actually has been pursuing these types of cases. As far back as 2016, now 7 years ago, the Department of Justice issued its antitrust guidance to HR professionals, in which it warned that the use of no-poach agreements or other sort of wage fixing agreements in a manner that, well, really no-poach agreements, in a manner that was unrelated to any legitimate larger cooperative arrangement, was going to be treated as a per se violation of the antitrust laws. And what I mean by a per se violation of the antitrust laws is it was going to be treated as presumptively harmful to competition, and it could be prosecuted criminally as a result. So that was the first warning, and the DOJ gave folks about 2 to 3 years to conform their, really 4 years to conform their behavior and stop using no-poach agreements to essentially suppress competition in the labor market. This arose out of really largely a number of different civil cases brought by the Department of Justice out in California in the entertainment industry. There was a lot of sort of effort by various companies, that movie companies and such, that were using really tech-savvy folks to suppress the sort of agreements to not compete with each other to get those employees to move over, which of course would have led to competition and higher wages for different employees as they had pursued opportunities to go work for competitors. And in this HR guidance, the DOJ warned, unless a no-poach agreement, for example, is part of a larger collaboration, then these were going to be treated as naked wage fixing and agreements. And so it shouldn't have come as a surprise to anybody in 2020 when the Department of Justice started pursuing criminal prosecutions against labor market participants. Primarily, in fact, I think exclusively so far, the prosecutions have really been in the healthcare space, visiting nurses and other sort of healthcare providers in specific geographies, usually some kind of metropolitan geography. And the DOJ enjoyed some early success. Motions to dismiss these indictments were denied. Federal courts, multiple federal courts, held that these wage fixing or no-poach agreements were per se violations, or could be prosecuted as per se violations of the antitrust laws. And I guess the only surprise might be juries have been very skeptical in finding that actually a violation of the antitrust laws has occurred. And in fact, the DOJ has now gone down 3 times, most recently in Maine, on these criminal prosecutions, with juries finding that there was no violation of Section 1 of the Sherman Act by the particular defendants. That said, the DOJ has procured a couple of plea agreements, and those plea agreements, have resulted in substantial penalties for those who participated. So, in terms of what employers should be doing, well, the first thing employers should be doing is looking at the HR guidance and making sure that their HR team is familiar with it. Antitrust, to me, it's funny because, as an antitrust lawyer, companies engage in annual training all the time for various things, EEOC compliance, various other kinds of training. Frankly, antitrust training is a good thing to add to the mix as you're looking at what kind of training to provide folks, specifically in your sales department, in your C-suite, and in your HR department, just given the recent developments.
So before I move on, I want to give Don an opportunity to add to this one, because I know that this is also an area that has been hot for you lately in terms of practice.
Yeah, it's interesting. It's an area where we kind of intersect on this. We often have situations where there is a litigation or a dispute before litigation. The parties will resolve their dispute. Perhaps one company is trying to stop a former employee from going to a different company. And they historically would occasionally agree, okay, company B, you took this one employee, you have to agree as part of our settlement, whether pre-litigation or post-litigation, that you're not going to hire our employees anymore because, you took this one person, that's unfair. So for the next 6 months, 12 months, whatever, you're not going to hire our employees. That no longer flies. There are real concerns that that could be seen as a violation of antitrust laws. Now you can structure it so that you have the hiring company acknowledging that some of the would-be plaintiffs' employees are bound by certain agreements that they shouldn't interfere with, but you can't simply have a naked, we're not going to hire anyone from there in the next 6 to 12 months. And that's something that a lot of our clients are surprised to hear, that that's no longer a viable option in settlement. So that's something to be aware of.
Yeah, that's interesting. And the overlap there, right, pretty clearly impacts both of our, or all of our practices, I should say. So I'm trying to be mindful of the time because I do want to transition to cover some state law issues, because one of the things that, as we were prepping for this program, most interested me about our conversation, Dawn, was just the sheer variety of legal frameworks that you have to keep in mind for your practice, particularly when you're working with multi-state employers and trying to, handle things across multiple jurisdictions. So, I was wondering if you could maybe give us an update on what the landscape looks like right now, what you see coming, and if there are, particular things that employers need to keep in mind when they're trying to sort through these issues.
Sure. Yeah, again, the proposed FTC rule is definitely the hot topic, but for my money, where you really need to be careful is at the state level, because restrictive covenants laws, non-compete, non-solicit, whether it's employee or customer non-solicit, even confidentiality laws, it would be a stretch to say that there are 50 different versions of those, but it's not that much of a stretch. It's really a patchwork of laws across the country. We've seen a ton of legislative activity in the last 10 years. This year alone, it's April 27th. There have been, I think, about 75 bills introduced in over 24 states. Not all of those are going to actually get very far, but we have seen in the last few years at least 2 states have a new agreement or a new statute, whether it's for non-compete agreements or non-solicit agreements. Some of the things that we are seeing are, for example, low wage bans. And again, it varies by state. It's not like every state that implements a low wage ban has the same threshold, under which an employee cannot be bound by a non-compete. So that's something to be mindful of. One of the really concerning things is we are seeing more and more states pass laws that prohibit use of out-of-state choice of law provisions or venue provisions. So it used to be that a company that had employees in various jurisdictions could say, all right, well, we are a Massachusetts corporation, so even though we have employees all over the country, it makes sense to use Massachusetts law. Now, that might work for a lot of employees, but there are states now where the legislatures have said, no, that doesn't work. The employees in California, the employees in Washington, a handful of other states have said, you need to comply with our laws. For our citizens, you better not be doing anything that we've already said is unlawful. So that's a challenge. And even more so, many of these states, it's very frequently the same states, they have rules on the books that say, if you do it the wrong way, if you have a non-compete for a California employee or a Washington employee that doesn't comply with our state's law, it's not just that that non-compete is going to be unenforceable. Now the company is at risk for liability, and there could be fines, there could be other penalties. We see a lot of fee shifting provisions. So, you try to sue someone, or even if the employee brings a declaratory judgment action in court saying, my employer wants me to be bound by this non-compete, I think that's unlawful under California law. The company, even if they weren't trying to actually enforce the agreement, could be liable for the employee's attorney's fees in bringing that lawsuit. So needless to say, it's a bit of a landmine. And we encourage you to engage counsel if you have employees in various states, which most of our clients do these days, to figure out, how are you going to draft your agreements to make sure that you are not running afoul of these various laws all across the country, and that you are both protecting the company's assets, but also making sure that the company is not at risk for liability.
So one of the other things that we had talked about was the issue of remote work, because that has also presented some challenges for employers. So not only are you dealing with patchwork of laws, but you also have folks that are working remotely and perhaps introducing certain risks, particularly in the trade secret and the misappropriation sort of context. So, are you seeing an uptick in your practice? Because it seems intuitive to me that if you have people working from home, it's probably easier to, you know, help yourself to company files if there's nobody sort of looking over your shoulder.
Right.
But, am I right on that, or is that just something that sounds right but isn't actually playing out in practice?
Yeah, there are really two issues that kind of dovetail together here with the rise of remote work. One, as I was just saying, the patchwork of state laws. It used to be that companies might have 10 offices in 10 different states. Okay, all we need to worry about are those states. Now, companies are saying, well, we're hiring anywhere because it's a remote world now. And if there's someone in Montana who wants to work for us and is competent, we're going to hire that person. So we need to have an agreement in advance that we know isn't going to violate Montana's laws. So that's the one thing that I wanted to point out. But in addition, you're right, in the remote environment, it is easier to obtain and transfer, use for a nefarious purpose the company's trade secrets. Number one, there are fewer opportunities for the employer to observe that there is something a little shady going on. Also, just generally speaking, as time goes on, the methods by which employees can misappropriate trade secrets, it's really just expanding. What was possible 10 years ago, that's still possible, but now there are 15 more ways that an employee can misappropriate a trade secret. And you're right, you don't have somebody leaning over their shoulder looking at their desk saying, oh, you're uploading that to Dropbox, you shouldn't be doing that. You also have people in the employee's home who might be, even if the employee's trying to do right by the company, a roommate or a spouse is trying to get access to that information. And it's a lot harder to see when that happens, when people are remote. So this is a challenge for our clients. And again, all the more reason to have good agreements in place for other restrictive covenants, which are sometimes the first line of defense. If you have a good non-compete agreement in states where they are enforceable, that's a good way to prevent trade secrets from going out the door to begin with.
Yeah, thank you. So I'm going to read the CLE code before we do a last rapid fire question to Brandon. So the CLE code for today's presentation is SS, as in Seyfarth Shaw, 9734. Again, that's SS, Seyfarth Shaw, 9734. Brandon, we have 2 minutes. You had mentioned earlier in the presentation about the Hart-Scott-Rodino Act, which, very briefly requires parties under certain circumstances to file pre-merger notifications with the FTC and the DOJ. And I wonder if you could give us a quick update on any recent changes in the HSR process or trends that we may or may not see going forward.
Sure. So, elections do have consequences, and, with the election of President Biden in 2020 and him taking office in early 2021, we have a new chair of the FTC, Lena Khan, and a new head of the antitrust division at the DOJ, Jonathan Cantor. Both have expressed extraordinary skepticism about continued consolidation in a number of different industries. And so we've seen that not only expressed in various speeches, but also in practice. One of the first things that occurred that the FTC pre-merger notification office announced in early March of 2021 was a pause to filing for early termination. That is, I said earlier that when parties file an HSR notification, they're required to observe a 30-day waiting period before closing. Now, in those obviously non-anti-competitive transactions, the agencies were willing to issue an early termination letter, basically to say within 2 to 3 weeks, nah, that's okay, go ahead and close the transaction. That temporary pause, we're now more than 2 years into it, and it ain't looking so temporary anymore. In fact, it's starting to look kind of permanent. There is no indication that early termination period is coming back anytime soon. The FTC has also begun issuing proceed at your own risk warning. So not only if you wait the 30 days, you can close, but the agency, FTC, is sending letters to some parties to transactions warning that the FTC hasn't completed its investigation of the proposed transaction. And so if you choose to close after that 30-day waiting period has expired, they very may well come back and and challenge that transaction at a later date and force you to unscramble those eggs. So there's just a lot of uncertainty right now for parties seeking to engage in merger and acquisition transactions in various industries.
Thank you. Well, that is all the time that we have today. I wanted to thank our panelists, Dawn and Brandon, for sharing your thoughts about what you're seeing in your practice areas and what we may see going forward. Thank you all for joining us today. We hope you enjoyed the webinar, and we hope to see you again in a future program. Have a good afternoon.
Thank you.